Tēnā koutou. This is a video presentation on the legal and social issue of predictive algorithm use in sentencing. Haere mai. That algorithm is the risk of reconviction, risk of re-imprisonment methodology, known as the RoC-RoI. We're going to evaluate the RoC-RoI and its identified issues. We will then look at case law in the Waitangi Tribunal, before turning to legislative approaches to AI and the solution for tools like RoC-RoI in the context of Aotearoa in 2024. Is the RoC-RoI a useful tool? Yes, absolutely. Should we use it as we presently do? No. We'll explore this today. The RoC-RoI tool was developed in New Zealand in 1995, during a period known as the AI winter. It became widely implemented in 1999. It was revised in 2002, and one of the previous contributing factors, ethnicity, was removed at that time. The RoC-RoI measure is an expression of the likelihood that a person will both be reconvicted in the future and be sentenced to a term of imprisonment for that offence, or within the next 5 years. The accuracy of this measure is said to be higher than human judgment alone. The RoC-RoI is a narrow AI trained on a rule-based system rather than an artificial general intelligence. It was based on the data of 133,000 convicted offenders. In analysing this vast knowledge base and applying its learning to a convicted offender, it automates a task that is too difficult and time-consuming for any human decision maker. RoC-RoI is a linear regression model. It calculates 16 static factors, including age and sex, age at first offence, frequency of convictions, number of court appearances and convictions, current offence category, sum of seriousness ratings for all crimes, number of previous imprisonment sentences, and total estimated time in prison. It then provides a number, which is the RoC-RoI score. For example, a 23-year-old woman who has 5 previous convictions for willful trespass, receiving, and unlawfully getting into a motor vehicle, who was then convicted of breaching her community work obligation, could be evaluated as follows. A risk of reconviction score, something humans can do without an algorithm, would be 0.94, or 94% chance of reconviction. The algorithm, however, calculating a risk of conviction and risk of imprisonment score, or RoC-RoI score, would provide the correct rating of 0.38, or 38% chance of reconviction. The RoC-RoI was designed for use by corrections as one of many considerations when deciding the level of management required for an offender on a community sentence, their eligibility for rehabilitation, prisoner security classification, and their suitability for release on parole. The use of RoC-RoI scores by the Ministry of Justice and Sentencing was a platform on which the ACT Party campaigned last year, despite this not being a listed purpose of the tool or an intention behind its development. Pre-sentence reports actually include a RoC-RoI score, and they're provided to a judge almost as a matter of course for sentences involving sexual violent offending. These scores, or the risk level derived from them, already do feature in judgments for extended supervision orders. Let's turn now to the key identified issues with the use of RoC-RoI in sentence decisions. AI discrimination, or algorithmic discrimination, is the banner issue for preventive risk assessment tools in criminal offending. AI discrimination is when AI perpetuates or worsens biases and societal outcomes for any person on the basis of a Human Rights Act prohibited ground, such as age, sex, or ethnicity. It is not a malicious act by the algorithm. It is caused by bias, lack of diversity, or proxies in the training data. Bias in the training data is where the data the machine is trained on reflects an existing bias in society. An example of this is the use of ethnicity as a predictive factor of future offending. This factor is part of the documented history of the RoC-RoI. We'll explore this in more detail shortly. Lack of diversity in the training data can also lead to discrimination. For example, earlier this year, New World West End and Rotorua used facial recognition technology that was trained mostly on European men, which failed to distinguish between 2 Māori shoppers. They trespassed an innocent woman from their store. An AI can also determine proxies and placeholders in the data that will still allow it to discriminate. In America in 2018, a recruitment tool was developed by Amazon that was not permitted to know the gender of applicants, but it systematically downgraded applicants who had unexplained periods of unemployment, such as maternity leave, or attended unrecognised universities, such as women's universities. Anomalous scores. Repeat drink drivers cannot be accurately assessed using the tool. Repeat drink driving did not present a real risk of imprisonment at the time RoC-RoI was developed. These drivers also tend to present as a low risk overall on the RoC. They have a high probability of reconviction, but a low probability of imprisonment. Child sex offenders will often present with RoC scores that are very low. This type of offending can go undetected for many years, and it cannot be well predicted in terms of reconviction and re-imprisonment within 5 years. This offending is very serious, insidious, and potentially devastating for victims. As such, offenders are usually manually classified as high risk. Youth offenders with extensive histories in the juvenile court cannot be accurately assessed using the tool because those histories are not available to the tool. Overseas convictions are not counted by the RoC either. Cases presenting one or more of these factors should be considered for professional override, a decision made by corrections staff as part of their human oversight of this tool. Fitness for purpose. Nowhere does sentencing appear to be listed in the purposes or functions of the RoC during its development or release. Despite that, this tool makes its way into the courts and sentencing process as part of an offender's PAC report from corrections in between conviction and sentencing. The right to explanation and the duty to give reasons. Judges are occasionally provided with explanations of the RoC within the PAC reports, explaining the algorithm and how it works. Those explanations are high-level, technical explanations. They are also impersonal explanations that do not provide information specific to the individual being analysed. The training dataset is pulled from convicted offenders who were imprisoned in 1983, 1988, and 1989. Many of the offenders assessed using the RoC today were not even born before the data that was used to train this tool. Criminal law has advanced and sentence length for various offences has changed. Some acts that were technically criminal in the 80s, such as homosexuality, were punishable by sentences of imprisonment. Double counting. There is a potential for an offender's criminal history to be counted twice. The risk arises because judges account for an offender's criminal history as a factor in sentencing. The RoC also provides its own decision, derived from the same static factors of the same history. Double punishment. It is beyond the remit of this presentation, but it is worth mentioning that with extended supervision orders in particular, there's a school of thought that says offenders who have already served their time should not be subject to further restrictions on their freedom. I simply highlight here that issues that are already fraught with human rights controversies, such as extended supervision orders, can be compounded by adding the input of a predictive risk assessment tool. Lastly, the ethical considerations of right and wrong come into play, what we might call a minority report effect. The idea that a person might be expected to face the consequences of a crime they have not yet committed reads like the plot of that dystopian movie, Minority Report. After all, an offender with a risk of reoffending, risk of reimprisonment score of 90% is very likely to commit a crime. But they might be one of the 10% of people who would not reoffend. And how is the judge to know? This problem is common to all predictive recidivism risk assessments, not just algorithms. I've also considered the issues of sustainability and job replacement in the use of this tool, since report writers could potentially fear that the AI is going to replace them. I had to discount this because use of the RoC has been business as usual since 1999, and it's widely accepted by its users to be a support tool for their roles rather than a threat. Case approaches to risk assessment. All case approaches that follow relate to supervision and detention orders for recidivist sex offenders whose sentencing was influenced in some way by the RoC or an equivalent automated risk assessment tool. State and Loomis. This case talks about the use of the COMPASS algorithm, a tool that draws conclusions from similar static factors to the RoC, such as the seriousness of the crime and the offender's history, publicly available information, and self-submitted information directly provided by the offender in their own responses to a questionnaire. In this case, an American judge ruled out probation for a repeat offender, Mr. Loomis, due partly to the COMPASS score of Mr. Loomis. He was considered to be an extremely high risk to reoffend. In sentencing him, the judge directly stated, "I'm ruling out probation because of the seriousness of the crime and because your history on supervision, and the risk assessment tools that have been utilised. I submit that in doing so, the judge may have implied that they counted the seriousness of the crime, Mr. Loomis's history, his history on supervision, and the risk assessment tools at the same time as they delivered the sentencing decision. It was, however, found on appeal that his sentence would have been the same regardless of whether the judge had applied the compass scores. This sentence was upheld on appeal, and it was ruled that the compass score was one of the main factors that may be weighed at sentencing, and also that Mr. Loomis could self-certify the accuracy of the public data and self-provided data used by Compass to obtain his score. In Fardon, Mr. Fardon was convicted of rape, sodomy, and assault and sentenced to 14 years imprisonment. At the expiry of his sentence, the Attorney General applied for detention orders. The Australian High Court in this case endorsed the use of predictive risk assessment tools to predict offending and justify preventative detention for dangerous offenders. The Australian tool was used to satisfy the court that an offender is a serious danger to the community because of an unacceptable risk that the prisoner will commit a serious sexual offence if released or released unsupervised. In CE of Corrections in McDonnell, Mr. McDonnell was convicted of repeat sexual offending, and at the expiry of his sentence, the Crown applied for an ESO for Mr. McDonnell on the basis of the ongoing risk he presented to the community. Submissions for the Crown and for Mr. McDonnell included clinical reports relying on the outcomes of various risk assessment tools, including the RoC. The Crown attempted to use Mr. McDonnell's moderate risk score as evidence of an antisocial orientation, which is said to be the second strongest predictor of recidivism after sexual deviance. Analysis by the defence and judge showed this was an incorrect use of the tool, and the RoC score was held to be of limited significance. An ESO of 10 years was ordered on the basis of other factors. Wharton and the Chief Executive of Corrections. Mr. Wharton was convicted on 2 charges of indecent exposure in 1979 and 2 representative charges each of sexual violation and sexual assault on a boy in 2008 for offending that occurred in the 1980s. An extended supervision order was ordered in 2018. The Court of Appeal quashed that order with reference to a doctor's report summarising risk. In their judgment, the panel highlighted the doctor's own words, based on a multi-method assessment of Mr. Wharton's risk of further relevant to offending using RoC-RoI, ASRS, VRSSO, and PCLSV ratings, and noted clinical factors. It's considered that there's a high risk of Mr. Wharton committing a further relevant offence while in the community. The panel then concluded their point, saying, "We see no need to summarise the risk assessment tool results because we view the doctor's own conclusions, expressed both in his reports and in evidence, as most relevant." This, in my submission, is one of the correct ways to apply the RoC-RoI in sentencing. Turning now to Belcher. Mr. Belcher was convicted of child sex offending and subject to an extended supervision order ordered in 2005. He appealed on the basis that an ESO breached fundamental human rights and was contrary to the evidence in his case. He was unsuccessful. The court helpfully took the opportunity to evaluate and categorise some of the limitations of the RoC-RoI throughout the case. They also identified the RoC-RoI score as an independent factor weighing in favour of the existence of Mr. Belcher's real and appreciable risk to children under Section 1071. Finally, we turn to the case of Tom Hemopo. In 2002, retired probation officer Tom Hemopo brought a claim to the Waitangi Tribunal claiming the RoC-RoI algorithm, which at that time considered ethnicity as a static factor, was racist. Before the claim came before the tribunal, Corrections removed ethnicity as a factor. So, no case. Use of ethnicity as a factor is an example of bias in the training data, causative of AI discrimination. The dataset RoC-RoI was trained on contained a disproportionately high Māori prison population, as has been the case in New Zealand for many years, and is still the case today. Our high prison population is reflective of a larger picture of systemic discrimination that has effectively deprived large numbers of Māori access to education, healthcare, income, and housing. Looking ahead, lack of diversity in the training data could well lead to discrimination also. Māori are disproportionately represented in the corrections population, and the training data set is representative of the prison population we had in the 1980s, not the one we have now. There also exist proxies in the data. For example, a Māori offender is more likely to have committed a previous offence, a serious offence, or have committed it at a younger age than a Pākehā offender, These are static factors considered by the RoC-RoI. They also create something called a feedback loop, where those convictions go on to lead to more convictions and more convictions and more convictions in the loop through the RoC-RoI. An internal staff email reported on by staff confirmed corrections staff were looking for other variables that they felt were highly correlated with ethnicity that might allow them to continue to use the tool without factoring ethnicity, but still get the same results. This makes it really clear that the tool can still disproportionately identify Māori offenders through their proxies and rate them at a higher risk level. Reducing the risk of algorithmic discrimination. Crime prevention algorithms overseas, such as Compass in the US, utilize a broad range of static factors like the RoC-RoI, supplemented by the offender's own answers to a questionnaire. According to the US's blueprint for an AI Bill of Rights, this is an acceptable approach, as long as those responsible for the algorithm proactively assess equity in the design of the tool, use representative and robust training data, guard against proxies, ensure accessibility for everyone at all stages, assess and mitigate for disparity in the system, and continuously monitor and mitigate the system. The EU takes a slightly different approach to algorithmic discrimination in their proposed EU AI Act. Oh, I take that back. In their current EU AI Act, just enacted this month. They state that all datasets used in training, testing, and validating the AI will be relevant and sufficiently representative. They are to be as free of errors and complete in view of their intended purpose as possible. Datasets must take into account the geographical, contextual, and behavioural elements of the AI and its functional setting. In exceptional circumstances only, AI providers may detect bias and correct deficiencies in their system by processing special categories of data. In the New Zealand Algorithm Charter, the section on partnership expressly acknowledges and promises to deliver clear public benefits by upholding treaty principles and embedding a Te Ao Māori perspective in the development and use of algorithms. In 2002, the decision was made to exclude ethnicity as a static factor in the RoC-RoI. I submit, of course, that Māori and Pacifica offenders are still disadvantaged due to proxies in the training data. It is appropriate in cases like this to ensure the training data explicitly includes factors that might worsen discrimination and bias, if not brought to the attention of the algorithm. Māori and Pacifica citizens have been systematically disadvantaged in terms of poverty, healthcare, education, and language. For these reasons and others, Māori make up 52% of people in prison, despite being only 15% of the general population. Proxies that still exist in the RoC-RoI tool include previous convictions, the seriousness of those convictions, and the frequency of them, all events that are over 3 times more likely to impact Māori than Pākehā, and all events that I submit can be mitigated for within the data. Finally, we take a look at the Tū Mai Te Rangi report. In 2016, Tom Hemopo, who we remember brought the claim against corrections to the Waitangi Tribunal back in 2002, in 2016 he brought a new claim to the Waitangi Tribunal, which was heard under urgency, this time directly aiming to address the systemic biases inherent in the Department of Corrections. Tū Mai Te Rangi is a report produced by the Waitangi Tribunal, which identifies a lack of broad measures that target and support Māori reoffenders. This provides some support for my argument that mitigating factors for Māori disproportionality should be intentionally provided to risk assessment tools like the RoC-RoI. The solution has got to be in legislation. Good legislation would help ensure human oversight of and accountability for the RoC-RoI and other AI tools with far-reaching or vast impacts on society. We could empower an AI commission to ensure good practice is followed. Our new regulatory framework could ensure ethical use of AI, with rules for the ethical use of datasets and for the use of risk assessment tools like the RoC-RoI. We could develop an act and regulations. A new law in a rapidly expanding sector needs to be written in a way that doesn't overly constrain innovation. So a good framework for this could be a broad act setting out principles at the top, regulations setting out the hard rules underneath and supporting it, followed by tertiary legislation that can be adapted apace with technology. This is somewhat similar to the Health and Safety at Work Act 2015, which is supported by regulations setting out rules such as worker participation, and then supported by regulatory instruments called safe work instruments, which can be developed and updated by the regulator without needing to go through the parliamentary process. This should be developed broadly in line with the principles outlined in the New Zealand Algorithm Charter. We can pick and choose appropriate elements for our country from overseas laws such as the European Union Artificial Intelligence Act, just come into effect this month, New York City's Automated Employment Decision Tools Law, and others. We can also bring in elements from our own existing legislation. We would require a regulator, such as an AI commission, with a commissioner whose powers include the ability to redirect and penalise those that breach the new legislation, and of course to engage with stakeholders to promote the innovation and ethical use of AI. Our rules for data sets should include a requirement for training data to be relevant, representative, and robust. Out-of-date and demographically irrelevant training data, such as prison populations from the 1980s, should never be permitted. Training data sets should be required to account for the specific context or functional setting in which they will be used, and must be required to account for and mitigate for any proxies in the training data. Human designers and operators of the algorithm and its training data must actively seek out proxies and disparities, with a risk management process to eliminate or mitigate data that may lead to discrimination or inequitable outcomes. Those responsible for the development and use of the algorithm have a duty to assess and monitor for any element with the potential to act in an unforeseen manner or lead to algorithmic discrimination. Our rules for using risk assessment tools should include considering the purpose of the tool. Risk assessment tools such as the RoC should not be repurposed for sentencing without significant adjustments to fit the court's context and functional setting. Using risk scores, recidivism predictions derived from risk assessment tools should never be counted as a separate factor by judges, in addition to the criminal histories and information already before them. The right to explanation, or the duty to give reasons. Explanations could be required to be a how explanation, limited to input factors and steps taken. This might be all that's required for a simple model like the RoC. As technology advances, AI algorithms like the RoC could be detailed and made accessible by explainable AI, which can explain why they work. Counterfactual explanations could also be provided in individual cases to allow decision makers, as well as the subject, to visualize the context of the data. In conclusion, the RoC is a valuable tool with significant drawbacks, particularly in its use for Māori and its use in courts. A robust legislative framework is recommended, with dependence on frameworks from overseas contexts, adapted for use in New Zealand. Rules should govern the use of training data and risk assessment tools in general, particularly when it comes to sensitive data or adverse personal consequences, as in the case of the RoC tool. Thank you for your time, and please reach out with any questions.